Judiciary Committee this Tuesday afternoon, March 18th. So we're just going to take a look at a joint resolution, JRS 15, which is actually something, there was a companion. I don't know if our companion resolution even got introduced or we just went with the Senate resolution. But even Karen and I and some others were working on this resolution with folks in the Senate, and we decided that it would start in the Senate and then would come over here. It's actually due for third reading today, but I wanted to put this in front of everybody today to take a look at it. And then I wanted to explain, I'll explain now and I'll explain again later if necessary, that in the Senate, it was only Michelle presented it. They decided they didn't need to hear from additional witnesses because of what the contents are. And I will also note that the Senate on second reading passed this 30-0 is what I understood. But nevertheless, I wanted to present it to everybody today. We're going to probably get it on Wednesday or Thursday. I can't remember. And I want to be ready to vote, but I also want to understand from folks if you feel that we must have witnesses besides the walkthrough and explanation from Michelle. So that's kind of the setup. And with that, I will turn this over to Michelle.
So for the record, Michelle Child's Office of Legislative Counsel, and we're taking a look at JRS 15. It is a policy, it's a joint policy resolution. As a policy resolution, it gets referred to a committee just like a bill. Instead of the ones that you usually see out on the floor congratulating the basketball team or something like that. So you are able to offer amendments to it, just like a bill. I've only worked on a couple other policy resolutions in my time here. I think the last one actually was related to, I think, supporting youth, trans youth. That was done a couple of years ago. And so the one that you have before you, it does not amend or change any law. It mentions, you'll see, I don't think I need to read it for you, but the topic obviously is joint resolution supporting Vermont's transgender and non-binary community and declaring Vermont's commitment to fighting discrimination and treating all citizens with respect and dignity. Then it talks a little bit about the steps that Vermont has done to protect the non-binary and trans community in Vermont. So in 2007, Vermont added gender identity to the list of protected classes in Vermont that extends to housing and employment, banking, public accommodations. We've also passed laws allowing amendments to vital records. And then most recently in 2022, you passed the SHIELD laws with regard to reproductive care and gender affirming care. So it's just making a statement about Vermont's commitment, and then the body votes on it, and copies are sent to the congressional delegation as well as Outright Vermont and the Pride Center.
Questions for Michelle?
I just have
go ahead.
initial question. So this is referred to as a policy document. I guess the question I have is, like, on premise, it seems like this is more an affirmation of our commitment to equity than policy itself. So I'm curious, like, are there any policy implications that are derived from this document? Or is it just how the document is described?
It's how it's described. I guess I'm not understanding the question about are we creating new policy or it's
reiterating. It's just reaffirming our commitment to equity. It's not creating any new policy.
Correct.
Okay. Other questions?
Right, exactly. No, that's a good
question. No, it's a good question.
Right.
Yeah, it's more of affirmation of policies that have already been passed.
They've already been passed.
I would frame it. So, I mean, my inclination is to follow the Senate's lead that we don't need to hear from individuals because this is all stuff that we've already done, but I'm open to hearing from folks who disagree and want to hear from folks. What do you think?
Well, I don't disagree. I just think it's funny that we have to affirm what we've already done. We've already done it. On any subject.
Yeah, yeah. Well, I mean, I'm just kind of.
It's almost like a pat on the back that we did this a few years ago. And I just want to remind you.
Infomercial for.
Well, I think- so I mean, I can.
Again, whatever the topic may be.
So there's some very anti trans and non-binary language out there and being pushed at the federal level and many other states as well. So I think at this point, reaffirming this for, to say that we're a very welcoming community of all different folks, I think that this is an important time to do that. So I mean, so that's, I think, the purpose for a reaffirming or affirmation of this policy. It's really to support these individuals, say in some respect that we have their back as well. Yeah. Barbara.
So I think many of you know, my district includes a lot of college students and I teach a class at UVM. And in the last few months, I've had several students questioning whether, like, are we safe in Vermont right now? Like, even though we've done this work, I think especially students, but others as well, don't know, is anything changing at the state level? I think the timing for this could be helpful to people who are wondering, is Vermont a safe place to be?
What about other threatened groups?
That's true.
What about the Jewish community?
Yeah, I mean, there's that. But I think it's specifically, I started working on this when there was an executive order that was really went a long ways to really diminishing individuals who are trans, individuals who are non-binary, and they are protected under a law in Vermont. And I think that really led to that. We weren't having the same issue with respect to other groups that were specifically targeted, really. So that's where this came from. I mean, yeah, I think that also just it seems to be that the individuals who seem to be the way things are going most vulnerable as far as how they are being attacked throughout in the nation. So that's another rationale for why it's specific to this.
We get hired on a weekly basis to go to synagogue.
That's interesting.
Yeah, we definitely are trying to cover that with the hate crimes law that we have as well. I mean, there's nothing that would prevent us from doing a separate resolution that talks about other individuals as well. I think that, this one should go ahead as it is, and we can certainly consider doing another resolution to reaffirm that as well. I mean, it does have language as far as discrimination, treating all citizens with respect and dignity. I think that but we're specifically, because of things going on, are in fact focusing this particular resolution on the population. Yeah, go ahead.
It's a follow-up question. Well, I guess two questions. One, the EO that you're referring to, was that in Trump 1 or Trump 2?
It was earlier this year.
Okay, so
Yeah, it was earlier this year.
and then my other question is, this is definitely in response to what's happening at the federal level, but do we have an understanding whether these communities have felt unsafe by policies passed here in Vermont? Because if that's the case, then I'd want to address that too.
Yeah, no, I've not heard. I don't understand, and that there is that. It is more on a national level, and we're saying, our laws are very welcoming and very respectful of all citizens, including transgender and non-binary. So, I don't see that's the issue. So we will have further discussion when we actually get possession of this, but I just mainly wanted to give folks a heads up. I think I'm not hearing that we need to, march a bunch of witnesses through on this. I think it's relatively straightforward, but we can certainly have more discussion when we get the document. I just wanted to be able to turn it around pretty quickly once we have possession of it.
When do you think that will be?
Say Thursday, if it's gonna be voted on, well, it's gonna be voted on today, so maybe. I'm gonna schedule it for Thursday. It may actually come to us on Wednesday,
Did they already do third reading today?
third reading day.
I know the Bloomer holds them for a day, and can't remember if that goes, I can't remember which way that goes, if it's
So maybe
back
Friday.
and forth. or-
Yeah, this week.
Yeah.
I can check. that.
Right, I appreciate it. All right, well, let's move on where we have witnesses. There's still ice cream left. So we're gonna go to S9 now. We're passing out that stuff.
What's that?
And S9 is a companion.
Procedure.
Yeah,
Go to.
It's
Environment.
Yeah, this is a companion build of one that Tom and a number of us, I think, are on as well. And it's just that it started in the Senate. I don't know how much language changed from what. I assume it's the same, but. Did they change it much? Did they amend it, or is this just as introduced? You recall?
Which one?
Oh, there's an amendment.
Ended to read.
You're gonna ask me what's the difference?
Well, no, Tom can ask you if he wants to.
My fifth bill today, so. I'm just winging it at this point. Thank you. Oh, there were any little technical tweaks, but the Senate enjoys a strike all. So for ease on the floor.
What's something? Did we pass something like this?
You worked in this statute.
Yeah.
In H222.
Okay,
This is-
I guess that's what it just seems very familiar.
Everybody ready?
Yeah.
Are you ready?
I'm ready. So we're taking up S9 as it passed the Senate. And the representative is correct. This is a familiar statute to you. We discussed it in the context of H222. So we're working in Title 12 and court procedure on the civil orders against stalking and sexual assault. So remember, those are available when someone doesn't fit within the category of the family or household member to be able to obtain a civil protection order under the Title 15 provisions. They fit within the construct of the orders in Title 12. They can get an order here. And what it's doing is it is just modeling the language that you have in the domestic restraining order title with regard to after hours orders for ex parte orders. So remember, there's always a process. So you can apply for a temporary ex parte emergency order. And then there's the final hearing and the final order that's 10 days later. And for the domestic orders, there's the ability to obtain one of those orders after regular court hours or on the weekends. That is not a provision that's contained currently for the orders against stalking or sexual assault. And so I think advocates reached out to Tom and I think Senator Hardy.
Food stocking though, does it?
No, it doesn't. And so this particular language is if you look at, so we're section 1 is talking about the orders there, and you'll see on subdivision 2, it says the court administrator shall establish procedures to ensure access to orders against sexual assault. So even though that whole section, is dealing with orders against stalking or sexual assault, when you're talking about the after hours access, it would just be for people who are looking to get an order with respect to sexual assaults. You'll, I'm sure, have Judge Zoney in to talk about it. There are substantially fewer plaintiffs seeking sexual assault than there are for stalking. Stalking, again, you'll hear from the testimony, sometimes gets a lot of kind of neighbor against neighbor and, their dog's pooping in my lawn and, or things like that. I mean, I don't mean to diminish the stalking because stalking is very serious, but I mean, there's a lot more And so the court thinks that they can handle the ones, and then, the circumstance would be, I think, if you have someone who is sexually assaulted and it's a Friday night and they feel as though they need an order of protection, should they have to wait until the court opens back up on Monday in order to get that order of protection? And that's not available to them currently. So I can just walk through the provisions here, but as I mentioned, they're just taken right out of your existing law for family members. So subdivision 2, it's just asking the court to establish procedures for after hours access, the courts to designate an authorized person to receive those requests. Again, we're just talking about the emergency orders. We're not talking about the final orders. It's just for the sexual assault orders. It can be requests made by reliable electronic means. See, page 2. Again, the top of the page that things can be submitted electronically. Subdivision C, affidavit is the basis for it and shall be sworn to or affirmed by administration of the oath over the telephone to the applicant. Subdivision D, the authorized person communicates the contents of the complaint in the affidavit to the judge, to the judicial officer, either by phone or by electronic means. Judicial officer decides whether or not to grant or deny the complaint and issue the order solely on the basis of the content of the affidavit that was submitted. And then the judicial officer tells the authorized person of their decision, and then that authorized person communicates it to the applicant.
So I know we're asking the court to establish the procedures, but is the thought that the person who was sexually assaulted would be the one to file it, or they're going through somebody else, like law enforcement or?
They are applying to the court for it. I'm
Right.
sure that some of the network and others can talk to you about, so they may have someone who is a victim advocate through the state's attorney's office, and maybe somebody with, one of the local groups, the local DV or sexual assault groups who are providing assistance to victims, who helping them, fill out forms, things like that. But they're it is the survivor who is the applicant for the order, and the plaintiff. And
The person that's doing it would be the parallel where it's doing the family abuse prevention. I'm assuming. That's the process they already have in place, and they were just gotta add it to that.
I have a question. So you're correct, Michelle, in that I guess we did work in the statute with H222, but we did entertain H64, which Rep. Oliver sponsored earlier this session. So I'm curious, where these two bills are different.
I mean, the bill as introduced that he
Yeah.
introduced,
Or is that this?
that's this.
That is this. It
Yes.
just went to the Senate, took it out.
Yeah, so oftentimes people will introduce the identical bills in both bodies and then if both folks want to take it up, they just make an agreement. Okay, you start with it and send it to us. And
Okay. And that's where I was like, I definitely have seen this before. I'm like, nothing. Yeah, right.
Wait, so I'm confused. So it started off as a House bill and then it got changed to a Senate bill?
It went to both, and then we decided to let it originate in the Senate.
Okay. So we don't do an H and an S there, so I don't get confused.
It's gonna be just this one. That's
Guess that takes you out of the equation.
Yes, it does.
Yeah.
Presented to.
What's the site for where you took the language from, the family? You said
Oh, yeah.
What's that for?
what's it? That's the family law.
So Tom, mention that other language as well, not just the just to confirm that we had the same issue with this one.
1107.
Yeah, that's, I know there's.
1106. Thank you very much. And then my only other question was, I'll look. The judicial officer are,
It's just the
Thanks, Tom.
terms that have been in those forever.
I'm assuming that that was it, that's in here in this one. Yeah. Are there other judicial officers that aren't judges? Okay. Cool.
I mean, you see it, it's unfortunate, but like throughout the titles, you'll see sometimes judicial officer, the court, you know, the judge, the whatever, and we just try to stay consistent with what's in there. So we're using the same term or whatever, but I didn't create it.
Yeah. Okay. Yep, thank you. All right, other questions for Michelle on this? Yeah, go ahead, Barbara.
So I'm assuming it's not effective on passage because we need time for the court to come up with a procedure.
Yes, and you can circle back around to Judge Zone on that. You know, it may be that you could do July 1st because they already have that. I think, you know, for me, when I'm just doing these, I'll just think about, well, do they have somebody in this court or do they have the staff for that? And I just kind of give them a little room. But, you know, certainly ask him whether or not if they can move it up a little bit.
Good, thank you very much. So we'll move Laura entirely. Yeah, I didn't believe back again. See that time?
I like that.
Second time.
Yeah.
Thank you for being here, Laura.
Thank you for having me. Good afternoon. Good afternoon.
For the record, I'm Laura Byerly, the Director of the Victims' Rights Project of Vermont Legal Aid. And I'm here because I do a lot of restraining orders. It's a large part of my practice, and I think this is a gap that's important to close. So victims of sexual assaults need to be able to access restraining orders in the same way that they would if they were assaulted by a family member. I mean, that's really the only difference we're talking about here. If you're assaulted by a family member, you can apply for an RFA after hours, and it's available to you while you're in the hospital getting your SANE exam, or if you're crying at a friend's house, or if you're hiding in your dorm room. Where I think this is going to be especially important to have, I think about college students. They won't qualify for an RFA, so they're not household and family members, so for the most part. And if they are assaulted, they need access to this. And maybe they don't want to go through the criminal process quite yet. This is available to them to allow them a little bit of space and a little bit of healing. I mean, when you think about the defendant in these cases, they've already proven that they're not able to respect a boundary and not able to stay away. So that's all this is asking for. It's giving access to someone in an easy and simple way so that they can get an order that simply says, leave this person alone. Give them a chance to catch their breath. I had the opportunity to speak, to work with my clients who were remote, and we would call the after hours folks together to ask for an RFA. And I cannot tell you what a huge help that has been for these survivors. Frankly, we don't all learn and communicate the same way. And if you're in the middle of a trauma, trying to fill out a form can sometimes be an overly daunting task. This gives survivors an opportunity to just speak and tell their story. And it's prompted. You get questions, you get prompts, you get somebody who can help you focus. And if they are remote, or if they just don't know what other resources are out there, this is a great way to access something relatively painlessly. And I think this is a very important change to make. I'm so glad you're considering.
Barbara.
Thank you for your work and for your testimony. I'm wondering, I spent a lot of time talking to students who have been sexually assaulted. And I'm wondering, I know that if they go through the Title IX process. It's very different. Will this bill apply if somebody is doing the it shouldn't matter, right? If they're doing the criminal process, or everybody will have access to.
These are parallel processes. So I also do Title IX work. So I'm often talking about the pros and cons of applying for restraining order as well, or going through the criminal process and what that looks like. So this just gives a survivor a different option. The Title IX process tends to be a little bit more focused on mutual restrictions, where this is a little bit more survivor focused.
I know that students have felt, I don't want to say railroaded, but sort of strongly encouraged to go through the Title IX process, and then have had sort of regrets about the lack of accountability for
Right.
So I just wanted to make sure that the language as is would be open to everybody.
Yes, I think this is important that it does. It's open. I've compared it to the Title 15 for family court RFAs as well, and it really just does give that keep that door open for those survivors.
And in terms of, it's interesting, is when Michelle first said this doesn't include stalking, I know we've heard testimony in here when we worked on stalking laws about horrible, horrible, horrible stalking situations. And I know that that's a word that does get misused when people casually talk about being stalked by somebody. But I'm wondering if you think we should be adding stalking in this or not.
I think we should start here.
Okay.
I know that there are concerns that there's only a few dozen of these cases filed every year. There are hundreds of the stalking orders requested every year. So I think this is a great place to start, and then we should revisit whether stalking should be available after hours as well, or if there's some other path for those orders. Maybe there will be an online option that might be less resource intensive. But yeah,
Tightening up the stalking definition for that, or I don't know what, but I can imagine some people who are in distress that they can't file
stalking this way.
something if they're being stalked and things get worse on a Friday night and they have no way to address it.
I just like sexual assault, though, stalking is still a crime. So I would encourage folks who are in that kind of a crisis to reach out to the law enforcement community if they feel comfortable doing that. Stalking is also something that our network programs generally will help with. So I would encourage that for a resource. Also send them, our way, and we can talk to them, but we're not an emergency service provider. I think we should maybe revisit this for the stalking issue in a later date, but I think it's a very important remedy or option for in the sexual assault context particularly.
Thank you.
Other questions? Ian?
Well, we have you here as a practitioner, and if we are mimicking the language from 15 BSA 1106, is there anything that's happening right now for requesting an after-hours RFA that could be improved upon that we could fix in language that we're proposing for assault?
Good question. I really think the devil in these cases comes with the training that the court administration, they have an excellent training program, but new people are, training levels vary. Like you get a really experienced person and they're much more streamlined and they know what they're doing. I don't think, I would, being a wordsmith, of course I would make it much more simple, but you don't need to. It mirrors the two languages and the courts tend to read the two statutes together.
Yeah.
So I think in that way, it's nice to have the clear mirror.
Yeah.
And then if we're editing and changing to, judge, as you had said earlier, judge instead of judicial officer or other language like that, it would be a good thing to consider. The other thing to consider is whether affidavit is actually something we think is necessary under these circumstances, or a sworn statement would be. But that's going into both the stalking and the RFA statutes themselves.
Yeah.
But I think keeping it as a mirror is helpful because these cases tend to be following the same levels of jurisprudence.
Yeah.
Like the Supreme Court will take it up and kind of interpret them both the same way.
So if the individual is trained effectively, the procedure that the courts have in place right now for after hours RFAs, if we were to do the same thing with sex assault cases, that would work well.
It does work well.
Great. Thank you.
Other questions? I don't see any. Thank you very much for being here.
Thank you for having me.
Appreciate your testimony. We'll go to Charlie next. Welcome back.
Thank you. Happy to be here. Let me do the chair again. I'm Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. Thank you for the opportunity to speak with the committee today about S9. We are very grateful to see strong support in the Senate for this bill, and also grateful for the companion bill that Representative Oliver and many others in this committee worked on. So as we've discussed in this committee, sexual assault protection orders are a critical legal tool for survivors of sexual violence. And when survivors can only request a sexual assault protection order during regular court hours, it leaves them at risks when emergencies occur on evenings, weekends, or holidays. A lack of after-hours access is particularly concerning in environments where a survivor is in close proximity to the perpetrator. That looks like college campuses and apartment buildings. Advocates at our member organizations who provide 24/7 support to survivors consistently report that survivor safety is compromised when they cannot seek a sexual assault protection order after hours. I'd love to share just a very brief story from one of our member organizations, Atria Collective in Addison County. They were called to the hospital for a sexual assault nurse exam early in the evening on a Friday after a survivor was sexually assaulted by an acquaintance. An advocate supported the survivor through the exam and safety planning. And as part of the safety plan, the survivor wanted to apply for a sexual assault protection order because the perpetrator knew where she lived and other details about her life. The survivor was assaulted on a Friday evening, so the court was already closed for the day, and so she couldn't file for a protection order until Monday morning. This left a gap in her safety plan for multiple days after the assault, where she didn't have legal protection to prohibit the perpetrator from returning to her home or place of work. We feel that survivors like Atria's client should have access to the protective measures they need when they need them, and that's why we are supportive of S9. I'd be happy to answer any questions, and thank you for the opportunity to speak with you all today.
Questions? Go ahead, Barbara.
So I'm wondering if you concur before on the questions I asked about the stalking piece.
Yes, I would say that I do agree with Laura. Of course, it is critical that victims of stalking have access to civil protective measures as well. Our member organizations do provide services to survivors of sexual violence, domestic violence, and stalking. And so, our members have a 24/7 hotline. Victims of stalking and other victims of violence should call anytime they need any kind of support. I do feel like there is capacity to make this change for sexual assault protection orders right now. Is something we hear about from our members a lot. And so we're really grateful for the opportunity to make this change.
And I know funding is very tight at a lot of your member programs. Is the 24-hour hotline in jeopardy in terms of funding? Is that something we need to keep our eye out for?
I think that this is a really critical moment for our services, and that, as we've shared, additional funding is needed to stabilize core services. And, so that we can keep the promise that 24/7 services are available to survivors. And, as the kind of landscape changes in all of the ways, we will be sure to stay in touch with the committee on impacts on our work.
Other questions? No, I think it's fairly straightforward, I think. So I appreciate your testimony.
Thank you.
That's all the witnesses we have for today. I just want to give folks a quick heads up on this bill. There's a part of the miscellaneous bill that we should be getting by the end of the week, but really won't be taken up for a couple weeks because it's really the last bill that we deal with. It has a provision that we may want to move into this bill dealing with service of process. It is a fairly technical change, but because it's associated with the same kind of stalking orders, we may want to move it out of the miscellaneous bill where sometimes things get lost and put it right here with this bill. And I'll probably, I just need to double check with our counterpart in the Senate to see if they have any consternation over us taking that approach as opposed to just doing it in this miscellaneous bill. Just want to give you folks a heads up that you might see that amendment possibly tomorrow with the additional witnesses that we have. Any other questions on that or other things that we're working on? I guess the last thing is that tomorrow I do have one witness on H-193, which frankly, I think that still needs some work, but figured that we would bring in one more witness later in the day. And on Thursday, prior to the show that Alicia and Angela and Tom will give us on the retention hearings at 10:30, we'll take up S-44, which I believe will be delivered to us tomorrow. And